Hi, it's Mike DelSignore, Massachusetts criminal and OUI defense attorney. In today's video, I want to talk about what happens if you're charged with OUI and the serious bodily injury. So first things first, in these kind of cases, the victim is going to have a major impact on your ability to resolve the case prior to trial. So first court date, know that the victim's family is going to be at court. They're going to be emotional. You want to be very respectful, be well-dressed. Don't have any reaction. They're gonna they could be crying. The victim could have very serious injuries, and this is the point where the victim's family and their emotions are probably most intense. However, so it's not going to be easy to get through the arraignment. I'll help you get through it. Enter a not guilty plea. If you have little or no record, the court may require sort of a nominal bail based on the seriousness of the offense, but you'll likely be released on conditions likely that you don't drink, you don't consume alcohol, so you probably have a scram device to prevent you from drinking. So you don't want to say anything. That could be media there, or if the victim's family, never make any statements. That's always the advice in any criminal case. You never want to speak. When you're charged with a crime, you never want to make any statements. You have an opportunity to speak, and that the only time you want to do so is on the witness stand. Never make public statements about an open criminal case, especially in a case where there's a serious injury to the victim, and certainly could upset the family and make the case harder to resolve. Because there's two aspects to it. In OUI serious injury, there's a felony and a misdemeanor version. DAs have the discretion to reduce a felony charge to a misdemeanor. The felony charge requires a 6-month minimum sentence. The misdemeanor charge allows for probation. So there's a vast difference in potential penalties when you're charged with misdemeanor OUI serious bodily injury versus felony serious bodily injury. And so what you want to do from the start, you want to be respectful of the victim's family. Take anything off social media. You don't want to have the victim's family research you, because they will look you up on social media and see that you're on vacation or something like that. You can do whatever you want to do. Just do it in private. Don't let it be known what you're doing. What you want to do as far as the case goes, you want to be doing alcohol treatment, get letters of recommendation, do counseling. You want to do things that address what the allegations are. That's never going to be a negative. They're never going to say, well, he's doing alcohol treatment, he must be guilty or she must be guilty. It's always a positive. So do the treatment, because then when the DA speaks, you'll want a resolution. Everyone charged with a crime wants to know, can I resolve this without a trial? So I'll submit a package to the DA on your behalf, indicating what you've done since the incident, your character, your work history, family history, all that. The DA will bring that to the victim. They'll have a meeting, and the DA will basically likely try to sell the victim on accepting a resolution. Usually DAs want to resolve cases. Sometimes the victim might be want a harsher resolution the DA thinks appropriate. So they'll basically take the information we provide and try to come to an agreement. So you want to give the DA something to work with. You want to give me, as your lawyer, something to tell the DA that you're doing. So you always want to be using your time productive, treatment, counseling, work, spend time with your family. You can do community service. Sometimes people want to do some community service, so that you could do that as well. All with the idea that not on the first court date, they're not going to care what you're doing. But these cases take a while. So as time goes on, the victim's family, they're going to want to move on. The DA will point out the weaknesses of the case, and at that time, when it's appropriate, what you're doing might have an impact to help us resolve the case favorably to you, which might prevent you from serving jail time, potentially, or reduce jail time. So these cases can still be won. So I want to always talk about the court process. So first court date, you're probably going to be on conditions. You want to be respectful to the family. And while the case is pending, do positive things so we can submit that to the DA in order to receive a reduction of the charge. Now, fighting the case, though, a lot of times accident cases don't have much evidence. It might just be a blood test. Blood test isn't scientifically reliable. If it's from the hospital, it's a screening test. There's ways to keep blood test evidence out from court so that the judge or jury doesn't consider the blood test. So we might need to hire an expert if there's a serious injury. You might want to get an expert. It's something I can help with. I'm a member of the National College of DUI Defense. I've gone to a lot of advanced trainings on blood cases, and I'll do everything I can to point out all your defenses to help you make an informed decision on how to handle the case. We might need an accident reconstruction. Maybe the accident wasn't your fault. We want to examine the black box. Usually there'll be crash data in serious cases like this. So when you're charged, call me right away. There may be things that we need to do immediately to preserve evidence to make sure you're in the best position to fight the case. We want to line up experts and begin showing the DA that we're prepared to take this case to trial. It's not an open and shut case, and that we will take it to trial if there's not a resolution. Because, the victim's family, they don't really want to go through a trial. No one wants to go through a trial. So if it looks like the case is, we have a strong defense, you're doing the right things, you might get a better resolution of the case, and that's a certain outcome. If you resolve a case, you always know what the outcome. If you go to trial, hopefully you'd be found not guilty, but if you're not, then it's up to the judge as to what the punishment is. So if you're charged with OUI, there's serious injuries, keep those tips in mind. Call me, text anytime. My name's Mike DelSignore, 781-686-5924. My passion is helping people charged with OUI make the best decisions for themselves, and I can help you on a serious case involving an accident or injuries when you're charged with OUI in Massachusetts.